Hello everyone, I'm George Whipple. First up this month, the confusion is over for employers. EEO1 pay data does not need to be submitted to the EEOC by the end of the month. In what may be the final chapter of the EEO1 pay data reporting issue, a federal judge in Washington, D.C. ruled that the deadline would be postponed until September 30th, 2019.
The chief data officer made a declaration to the court very specifically saying the EEOC cannot do it on its own. They have to go to a third party. They have to go outside of EEOC to a company or an organization to actually be able to pull this data together at the court's direction. So you have the gender and race ethnicity data that everybody's used to reporting, and then you have all of this new paid data trying to be overlaid over that existing framework, if you will. In addition, you have to provide hours worked for each of your employees. So you have 80,000 employers, tens of millions of employees, and now you have to not only provide them with pay data in the aggregate based on these categories, you also have to do hours worked.
The EEOC has decided that employers must file both 2017 and 2018 pay and hours worked data by September 30th, 2019. They will begin accepting this new data in mid-July. Heading into May, we have more clarity on class arbitration. The United States Supreme Court recently found in Lamps Plus versus Varela that an employee could assert only individual and not class action claims in arbitration because the arbitration agreement did not explicitly authorize class claims. Reversing a decision from the Ninth Circuit, the court found that an obligation to engage in class arbitration is not implicit in an arbitration agreement under the Federal Arbitration Act, and that explicit authorization is required to compel a company to arbitrate on a class-wide rather than individual basis. The Supreme Court has agreed to hear 3 cases in its October 2019 term that address whether Title VII's prohibition against sex discrimination extends to discrimination on the basis of sexual orientation or gender identity. 2 courts, the Second and Seventh Circuits, have held that Title VII covers sexual orientation, while the 11th Circuit found the opposite. Separately, the court will decide whether Title VII prohibits discrimination against transgender people. Oral arguments are set for fall 2019, with decisions expected in 2020. With a growing number of jurisdictions legalizing the medical and adult recreational use of marijuana, it's no surprise to see the emergence of additional employment-related laws. The New York City Council recently passed a bill that would prohibit marijuana drug testing for prospective employees as a condition of employment. The Council passed the bill on April 9th, and employers will have to comply beginning 1 year from the date it becomes law. The law would restrict employer use of tests for marijuana and THC. The bill is the first of its kind, and we may see more of the same in jurisdictions across the country. We'll keep you updated. And finally, the House Appropriations Committee heard testimony last month in a hearing entitled Combating Wage Theft, the Critical Role of Wage and Hour Enforcement. Epstein Becker Green's Paul DeCamp testified at the hearing to provide insight on the concept of wage theft and the state of wage and hour enforcement, as well as how these issues affect employers and workers. To hear more of Paul's testimony, make sure you check out the audio podcast of this show, available wherever you listen to podcasts. Thank you very much for watching. We'll see you next time.